Get up to 2 months of free podcasting service with Libsyn. Check out the show notes for your promo code to get started podcasting today.
And, that's another area that's so important and often overlooked is when we have family members, loved ones, children with special needs. So that is an area that we're able to plan. And within your foundational plan, so how we were talking about revocable versus irrevocable. So within your revocable trust structure, if you do have a beneficiary like a child with special needs, the best practice to set up, how they're to receive those assets is through a special needs trust.
Welcome to the Unlocking the Club podcast, where we host honest and direct conversations about journeys of access, personal truth, and reclaiming space. We share our truth so that you can find the key to own your truth, honor your journey, and reclaim your space. Grab your keys, your wallet, your phone, and invite your friends to meet you at the club. Here's your host, Angela Taylor.
Hello, everyone, and welcome to a very special series of Unlocking the Club, where we explore one of the most important yet often overlooked conversations that we can have: estate planning and elder care. I'm your host, Angela Taylor, and I want you to know that my inspiration for this series was the fact that over the past few years, my family, friends, and I have all learned the hard way about the critical importance of having a will or trust in place. When unexpected moments arise, not having a plan can leave families vulnerable, and I've seen firsthand how it can create chaos during already challenging times. Recently, I conducted a poll, and the results were eye-opening. 80% of people between the ages of 20 and 65 do not have a will or a trust in place. Even more striking is that most of those who do, in fact, have a plan in place actually only took action after experiencing a tragic event. National data supports this as well, with studies showing that a significant majority of adults, particularly within Black and BIPOC communities, have not taken steps to secure their legacies. And when we fail to plan, we leave our families with legal battles, financial burdens, and emotional stress that can take years to untangle. That's why we're dedicating an entire 12-part series to unlocking the essentials of estate planning, together with two brilliant legal minds, Shane Jasmine Young from Young Law Group and Berlina Green-Tuluska from BDG Law Group. We'll break down what you need to know about protecting your assets, building a legacy, and making sure your loved ones are cared for when it matters most. Our goal in this series is to equip you with the knowledge and the tools to take action now before life forces you to. Whether you're just starting out or you're navigating the complexities of caring for aging loved ones, these conversations will give you the clarity and the confidence to plan for the future. So grab your notebooks, tune in, and let's unlock this critical conversation together. Welcome to Unlocking the Club's special series on estate planning and elder care. Hello again. I'm Angela Taylor, your host for Unlocking the Club, and welcome to our special 12-part series on estate planning and elder care. On today's episode, we're going to talk about protecting your assets through trusts. Trusts are those powerful tools for protecting your assets and ensuring that they're distributed according to your wishes. So today we'll explore the different types of trusts, how they work, and why they can be an essential part of estate planning for asset protection. Joining us today to discuss trusts is Shane Jasmine Young of the Young Law Group. Shane, thanks again for joining us.
It's an honor to be here. Thank you so much for having me.
Absolutely. I'm learning so much from you and Verlina in this series. And so again, so grateful for you being in this space and being so generous with your time and your resources for our listeners and viewers as well. And I want to jump into this trust. You keep hearing about it thrown in with estate planning or wills and not sure if they mean the same thing or not, but what exactly is a trust and how does it differ from a will in terms of asset protection?
Right. So great question. And one of the most common questions that we get actually when it comes to estate planning. So most of us have heard of these terms, right? A will, a trust. So a will is really a document that deals with the disposition of your assets. It really just says who gets what. So a will does not avoid probate. It actually has to be filed with the probate court and it becomes a public record. So this is what a lot of people don't realize is when you only have a will, you're not keeping things private. You might get to say, okay, I want my kids to receive, my assets, but they still have to go through the probate process, which probate is a court process that your family and your estate have to go through when you either don't have a will or a trust, you have no plan, or you only have a will, or you have a trust, but your plan is not set up properly. So a lot of different ways you can land in probate, which we typically want to avoid, right? So probate, as I mentioned, is a court process. It's very expensive. It typically takes a long time. It varies from state to state, but the average is usually about 18 months to 2 years for even simple estates to have to go through this process where creditors are the first ones that are able to make claims against your assets. And these creditors are able to look in and see what assets are actually in your estate. So nothing is private. Also, whoever your executors are, their information is also public. So their addresses and, other things that you would consider confidential are part of the public record. The beneficiaries or your heirs are also public. So this is how a lot of predators will prey on young people, older people, everyone in between, because they can see when someone is going to receive an inheritance and how much that inheritance is. And, there's just so many disadvantages. It's an outright distribution. So if you have young children, they're receiving assets, at age 18, regardless of how financially sound, their decision-making is, which can be really dangerous. Imagine, being 18 and receiving even, a modest life insurance policy of, $100,000. Young children, young adults in particular, make poor decisions, and can take them completely off track. So those are some of the, the downsides or disadvantages of only having a will or not a proper plan in place. It's going to land you in probate. It typically costs about 5 to 8% of the value of your estate. And let's talk about that for a moment. So when we talk about estate value, the value gets counted by these assets that you have, that we add up the total. So if you have real estate, your bank accounts, investment accounts, life insurance, that all goes into your countable estate value. And so on $1 million estate, and this is even if you have a mortgage. So say you've got a home that's valued at $500,000 fair market value, but you still have a $300,000 mortgage. The mortgage, doesn't matter. It's the value of the asset that gets counted into this countable estate. And so when you look at that, 5 to 8% of, $1 million estate, which more of us have these types of values than ever before. That's $50,000 to $80,000 in probate fees and costs. And that's just the probate side of it. Now, if you have an estate that's subject to estate tax, there is state estate tax. So every state is different. Nevada, another reason that a lot of people are here is we have no state estate tax. That's another benefit of being in Nevada. But, other states may have a state estate tax or a death tax. Plus there's a federal estate tax that can be applied no matter where you live, which is currently 40%, which is on the low end. Now, it doesn't apply to most of us at this moment in time because the freebie or exemption amount is very high. So only estates that are valued at over $13 million would be subject to that federal estate tax. But the laws are changing. We talked about this in a prior episode where depending on who's in office, these laws fluctuate. So the important thing is to plan early so that you avoid a 40%, 50%, tax, 5 to 8% of the value of your estate. That's really important. So when you only have a will, just kind of going back to the original question, the difference between a will and a trust, when you only have a will, you don't get those protections from probate, from taxes, because it's a very basic document. Now, a trust, on the other hand, is a much more comprehensive set of documents. And when we talk about trust, there's different types of trusts. There are two main categories of trust that we touched on earlier as well, but they are revocable living trusts and irrevocable trusts. So the revocable living trust is the main vehicle that we utilize on the estate planning side. That's what most people have when they set up an estate plan. Revocable means you can change it at any time. So as your life changes, your assets change, your family relationships evolve, we're able to make updates and amend your plan very easily. So that's with the revocable trust. The main benefit of the revocable trust is we can address all types of contingencies, the who, the what, the when, the where, the why, and the how of how things are to happen, the people that are involved, how your assets are going to be distributed. We can include asset protection for your beneficiaries. Of course, we avoid probate, and we can avoid taxes, all different types of taxes. So that's the main benefit of the revocable living trust. We can handle things privately and immediately. Now, because it's revocable, and this is the common misconception, people sometimes believe that they have asset protection during their lifetime. So, if you're a business owner and you're sued, or if you cause a car accident and there's a lawsuit against you, or if you owe the IRS, or if you owe any other creditor or have debts, that revocable living trust does not shelter your assets during your lifetime from those third parties, from those creditors. So they can reach those assets in your revocable trust. Now, you can build in asset protection at different levels. Like if you're married, you can build in asset protection for your surviving spouse and also your beneficiaries. But while you're alive, you do not have that airtight asset protection that some people think they have. So that's a common myth that I have to often, bust. I have to debunk that myth. Now, another type of category, I should say, of trusts is irrevocable. And there are lots of different types of irrevocable trusts. So they vary from, different types. But the two main characteristics that they share are, one, they're irrevocable, meaning that technically you can't change the terms of the trust. So once you put that trust in place, it's supposed to stay, as is. And I'll come back to, there's a little asterisk there because Nevada has some special laws that allow us to make changes in certain circumstances or have more flexibility. But typically with an irrevocable trust, particularly with these types of trusts outside of Nevada, once you put those terms in place, that's how they are to stay. So that's one common characteristic among irrevocable trusts. Another common characteristic is there is some type of enhanced asset protection component or purpose behind these irrevocable trusts. So I mentioned earlier, irrevocable trusts can include the Nevada Asset Protection Trust, which is something that you put in place in Nevada. You don't have to be a Nevada resident. And I'll share a little bit more about, how that particular trust works. Other common irrevocable trusts are Medicaid asset protection trusts, where if you are trying to avail your family or family members of certain Medicaid benefits available through the state, but you have assets so you don't qualify, a Medicaid asset protection trust can actually shelter those assets so that they don't get counted against you and you can actually qualify for those state benefits. So I know, elder law and long-term care planning, that's part of this series. So that's one of the tools that's available for that type of planning, because most people can't qualify for it, if they have a certain level of assets or income that's coming in. So that's another type of irrevocable trust. The ILIT is a life insurance trust. So if you have a very high value in life insurance, benefits, that gets counted into that estate value that we were talking about earlier. And that can take you over that exemption, especially as these laws are going to be changing to where you could get hit with that 40, 50, 55%, whatever that tax rate is on the federal estate tax. So what the ILIT allows you to do is basically pull out the value, pull out those life insurance policies to take that amount out of your countable estate. So you still have it there for your family's benefit and for that generational wealth, perhaps, but it's not counted in your taxable estate. And then similarly, the Nevada Asset Protection Trust were able to implement certain of those similar types of strategies to be able to, bring down that countable or taxable estate value. But the other benefit is any assets that are in that Nevada Asset Protection Trust are sheltered from creditors, from third parties. And other states, about 17 other states offer some similar types of domestic asset protection trust, but none compare to the level of protection that you're able to get with a Nevada Asset Protection Trust. And the cool thing is you don't have to live in Nevada in order to take advantage of this particular trust. So I'll share a little bit about, why Nevada and why this trust is so helpful to anyone, whether you live in Nevada or not. One is there are no exception creditors, which means that no matter who the creditor is, once those assets are properly held within that trust, they can't come after those assets. They're sheltered for your lifetime. So in other states, they may have a list of creditors that it's like, oh, well, if you're on the list, then you actually can pierce the veil and you can get access. In Nevada, there are no exceptions. No creditors are able to pierce that protection. So that's a really huge benefit. Another benefit is we have the shortest statute of limitations or vesting period when it comes to the trust. So when you set up this trust and you put assets in the trust, you actually get protection from day one from future creditors, but from existing creditors, if there is an existing claim or creditor, they have a 2-year period of time within which to make a claim. If they don't make a claim within that 2-year period, they're barred forever from making a claim. So even if they do make a claim, it doesn't mean that they're going to get access to those assets. They still have an uphill battle. So, the Nevada Asset Protection Trust really offers many layers of protection and leverage when it comes to sheltering your assets, avoiding expensive litigation, utilizing this as a bargaining chip and other leverage. So those are some of the benefits. And then going back to the component or the characteristic of it being irrevocable. Well, Nevada actually has a very permissive decanting laws. So what that means is you can actually withdraw or distribute out the assets from that trust and basically start again and put a whole new trust in place with all new terms. So in other states, you can't do that. And Nevada also allows for what's called a trust protector, which means that you can identify a company, a law firm. We typically serve as the trust protector for our clients. And what that role involves is protecting the trust, as the name implies. So anything that has to do with the grantor or your wishes, your intent behind setting up the trust, we're able to make adjustments according to those wishes so that there's this level of flexibility and fluidity, because things change, right? You don't want to necessarily be stuck with the same, terms as, things may vary. So that is another benefit for sure of having, this Nevada Asset Protection Trust. And you might have heard in the news, the media mogul, Rupert Murdoch, the Fox 5 media mogul. So his estate is actually in court right now while he's still alive because he does have an irrevocable trust. It's based in Nevada. He doesn't live here, but why did he set it up in Nevada? Because Nevada has these great laws, right? But he set this up years ago. And initially he set it up to where his 4 children would be involved in managing, the estate, the assets, this media empire. But he's recently decided that he wants his eldest son to be the one that's in control. Well, because the terms are irrevocable, he's actually having to go to court in order to change those terms. However, if he had a trust protector, like if Young Law Group was his trust protector, then we actually could have changed these terms and we could have done it privately. But now there is some, a little bit of a public nature to it, because now people know that he's having to go to court. We don't know the terms of the trust because that's still private. So Nevada is still very much a protectionist state where the trust documents themselves are not part of the public record, but the fact that he's having to go to court to make this change is public. So it's very interesting. I was interviewed by a few different media outlets regarding this particular case. And, it gives us an opportunity to bring to the forefront the importance of planning ahead, why Nevada is, the question that, the Wall Street Journal and, other media outlets have asked. And that's why, because of all these different benefits that Nevada provides.
Yeah. Well, and, one of the things that we're talking about is get in the game, right? At a minimum, play checkers. But what Shane is talking about is how to play chess. And I remember years ago when I started some businesses, just trying to figure out where I wanted to form a business. I was still moving around to different locations. I wasn't sure what state I wanted to form these businesses in. And so I did some research. I'm like, well, where do all the rich people start their businesses, right? It was Delaware, it was Nevada, and then it started to be Wyoming.
Mm-hmm.
And because of these protections that they have, and so the Rupert Murdochs or whoever, it's no surprise why Nevada is one of those places, but certainly pay attention to where people with a lot of money are trying to protect those assets because they don't want to give them up at all. And so I love that you shared that story, Shane, to give us a little bit of context about the value of being strategic. Let's play chess, not just, let's just play at least a minimum play checkers. Okay.
Right.
Let's get in the game and get in the game today. But when you're looking at being in the game, let's play chess. Let's play chess, particularly people in marginalized and historically excluded identities, we need to make sure for our legacy, for our ancestors, that we're protecting our assets as much as possible. And I hate when I hear families losing property, et cetera, because no one's paying the property taxes, or they didn't have a will in place, and all of these different things, and the state is taking over things. Let's play chess. Let's flip the script and play chess. And I'm so grateful for Shane for teaching us some of the nuances that will allow us to play chess. And as you're talking about these trusts, Shane, I was thinking about our last conversation about blended families. And in blended families, or just in general in families, sometimes there's special needs at play or mental health. How do special needs trusts work, and why are they important for families with disabled or vulnerable loved ones?
Right. And, that's another area that's so important and often overlooked, is when we have family members, loved ones, children with special needs. So that is an area that we're able to plan. And within your foundational plan, so, how we were talking about revocable versus irrevocable. So within your revocable trust structure, if you do have a beneficiary like a child with special needs, the best practice to set up, how they're to receive those assets is through a special needs trust, where we can appoint a trustee that's going to manage those assets for that beneficiary so that they're taken care of. So your child or whoever has special needs is taken care of, and those assets are available for them, but they're not tasked with managing the assets because, they might not have the ability or the capacity to do so. And it allows us to keep them eligible for any benefits that they're receiving through the government, through the state. So that's another area, when we talk about asset protection, different types of trusts, revocable, irrevocable, all of these different types of strategies and tools that are available. And we don't expect everyone else to know these things, right? But these topics come up in conversation when we have the life and legacy planning session. So that's another reason why I encourage everyone that's listening, everyone that's watching, to schedule your complimentary session. And we're offering it complimentary. Normally it's $750, but because you are part of, the Unlocking the Club podcast, family, the audience here, this group of amazing people led by, you, Angela. And, again, thank you for providing these resources in this platform. It's so, so important, especially for our community. Take advantage, you that are listening and watching. watching now, because there's so many things, and doing things online or working with someone that's transactional, you're not going to get into the depths of the conversation and the guidance and the counseling that you really need in order to really protect your family and your interests.
Yeah, that's so important. So important. And you mentioned kind of the trustees or the roles that folks play. Like, what role does a trustee play in managing the trust? And how do you choose the right person for that responsibility? I want to roll up my sleeves and get to some of the tactical aspects of
Right.
estate.
Yes. So a trustee is, as we talked about earlier, it's one of the main parties that's involved in a trust. And so there are there's a different scope or level of involvement depending on, what this trustee's designation is. So the first level of trustee is, after you pass away, that's the person that's going to step in. It's, kind of like the executor, right? When you have a will. So this successor trustee is going to marshal the assets. So they're going to look at all of the assets that are in the estate, and then they're going to make sure that the assets are distributed according to the terms of the trust. So if it's an outright distribution, those assets are liquidated, that person or those beneficiaries receive those assets, directly into their name, and that's kind of the end of it. With an outright distribution, that is a little dangerous, especially when you're dealing with young beneficiaries, that may not be financially mature. There's no oversight, there's no protection, there's no guidance there. So we want to be careful about that. If we are passing assets through a special needs trust, as we talked about earlier, or through a lifetime asset protection trust, which is essentially a Nevada asset protection trust, but it's for your beneficiary or beneficiaries. There are sub trusts that are built in within your plan. So this is another really cool thing when we talk about generational wealth and starting, creating that wealth, from our generation and then going to the next. So if you have any of those trusts that are part of your plan, and they're not as expensive as you might think, you can actually build it into your plan for $1,000. So, when you look at like the impact that you can make with these types of trusts, and that's because it's part of your overall plan, a more comprehensive plan. So when you have those trusts, whether it's a lifetime asset protection trust or special needs trust for your beneficiaries, you're going to have a trustee that's appointed, and it might be that original trustee. It could be different though, depending on, the nature of the relationships and, how you want things to be managed moving forward. But that trustee will oversee the assets that are in that trust for that beneficiary, and they'll be able to make decisions. Now, you can be as specific as you would like as far as laying out the parameters and the contingencies for how you want that money to be utilized for the beneficiary. If you want them to have a withdrawal right, if you want them to basically, have money distributed at certain points, if you want to give them incentives, like, okay, if you go to college or if you volunteer or if you do this or that, then you can kind of give them bonuses or incentives for that. When it comes to the lifetime asset protection trust, that those are things that we can build into that plan. And then for that particular type of trust, when that beneficiary is old enough and mature enough and can make smart fiscal decisions, they can actually be a trustee of the trust, a co-trustee, or even the sole trustee of their own trust. So that's a little different than the special needs trust, because with the special needs trust, that beneficiary is not going to typically be a trustee of their own trust. We're relying on someone else to manage those assets and make sure that that beneficiary is cared for and, that they have what they need. So the trustee is able to access the funds in either case and make sure that those beneficiaries have, their main, things that they need to continue, with their day to day. So things that they need for school, medical expenses. Of course, if you're building in other incentives or, particular parameters, you're able to do that. Otherwise, it's left to the trustee's discretion, when to make those types of distributions. I will make a note though, if we do set up a special needs trust, we do have the ability to convert it into a general needs or a lifetime asset protection can trust. So if it was a matter of having special needs, during a particular time period, but now that's not the case, then we can actually give them the other asset protection and some more involvement. But the benefit is if they are receiving benefits from the government, we don't want to disqualify them. We want them to be able to receive those ongoing benefits for those special needs but still have the access or the assets there for them. Now, you asked also, okay, well, how do we decide who would serve in this role? And this is a really important decision that we're making here when it comes to any type of trustee, because it is a fiduciary responsibility. You're giving someone the ability to access your money, your assets. And so there is a level of trust there that you want to have with respect to who you're designating. And we ask that you designate or you think about at least 3 people. You don't have to have 3, but you want to put them in order of, how you would want them to be called into action. So first, second, third, it could be a friend, it could be a family member, it could be someone that you trust. It could also be a third party. So sometimes families are, like, well, I don't have any family members or I don't trust anyone with that responsibility. So you can actually appoint a third party, like a trust company, a law firm, different businesses offer those services. So that is an option as well. And then another benefit or component of your plan that you can include is what I mentioned earlier, as far as naming Young Law Group as your trust protector. So not all states offer this, and not all firms, most firms actually don't, but this is a service because we're full service and we want you to have, the advantages. We want to give you the keys, right, that we're talking about unlocking, access and, unlocking the club, right? So this is another key to that is you can have a trust protector so that if anything does change and you don't have another trustee that can step in, because they can decline. That is the other thing. Even though you name someone, it doesn't mean that they're forced into that obligation. They can decline and it would just go to the next person. Now, if there's not a next person, that's where the trust protector can step in and say, okay, well, in this interim period, we need to, take care of these matters. Here, let's appoint, this person or party as the trustee. So having that trust protector allows for us to be more involved. It allows for you to have more peace of mind knowing that, no matter what, we're able to avoid having to go to court, for a judge to now step in and decide what's going to happen with respect to your plan. Just gives you that peace of mind and flexibility.
All very, very, again, fascinating, important. And now I'm going to ask the question that everyone wants to know, Shane. The naming convention for trust. Now, I've heard a couple different things. I got cutesy with it. It was like, oh, I want my name, trust or something. And then I read something about you may not want to have your name as part of the trust. Like, do you have any guidance or recommendations for that naming convention for the survivors amongst us?
I do. And it really is a case by case situation. But the typical naming convention for a revocable trust would be your first and last name, living trust, dated October, 22nd, 2024, whatever the date is that you're signing the documents. So that's the typical naming convention. Now, some people like to have a little more anonymity where they don't want their name in the name of the trust. And so you really have 100% freedom to decide what you want to name your trust. And I've had some pretty interesting names with respect to families and clients that have named their trust after their dog, for example. So it was like the Captain, and I'm changing the name, the Captain Cody Living Trust. I've had another interesting one was the You're Welcome Living Trust, because they were basically saying, here's my gift to you, my children. So you're welcome. And, so we've had all different variations. So you really have the freedom. Sometimes clients prefer to have a shorter trust name and or anonymity. So you might use your initials. So, you can, shorten the naming convention that way. When it comes to your irrevocable trusts, it's really whatever you want. Sometimes it's just, the Taylor Irrevocable Trust, or, the Young Irrevocable Trust, or it could be, the Taylor Dynasty Trust, or whatever you want. It could be the Unlocking the Club Asset Protection Trust. You really have whatever flexibility and freedom that you would like to have in naming it. But if you are looking for anonymity, especially with the irrevocable trust, you don't want to use your name for that because it is actually a separate legal entity. You're going to have a separate EIN. So it is removed a step from you, versus with your revocable living trust, it is tied to your social. So that's another distinction between those two trusts.
Wow. A wealth of knowledge. Once again, thank you for sharing and distilling this down into kind of digestible bites, if you will, for all of us that are listening or watching. If there is one more piece of advice from today's conversation about trust, what would that be, Shane?
So my piece of advice would be to have these conversations now. Talk to your family members. If you're married, talk to your spouse. Talk about the legacy that you want to leave. What are the outcomes that you want? Do you want to avoid probate? Do you want to avoid taxes? Do you want to create this opportunity for generational wealth? Get really clear on what those things are that are your priorities, that are important to you. And of course, take advantage of the resources that we've discussed during this podcast and throughout this series. Go to our website, watch that on-demand video. I have other videos, including information on the NAPT, the Nevada Asset Protection Trust. So, please utilize those resources, get information, schedule your complimentary life and legacy planning session, and take advantage of the discounts that we're offering.
Wonderful. Well, Shane, it continues to be a pleasure having you on Unlocking the Club as part of this special 12-part series on estate planning and elder care. Thanks for sharing your expertise, for making these complicated topics feel approachable and doable, and for just being you. I appreciate how you're so accessible with this information. Sometimes this type of information, you might feel like somebody's being condescending, but it's so accessible because of how you're able to craft and narrate, again, a lot of complex information to our audience. So I appreciate that.
Thank you. Thank you so much for having me.
Absolutely. Well, another important topic. I hope you all, again, are taking that message away. There's something that you can do here and now. Put your future in good hands. Reach out to either Relina at VDG Law Group in California, or with Shane at the Young Law Group in Nevada and Vegas. They are going to help you and your family be protected. Once again, for Unlocking the Club, so grateful for our special guest today, Shane Jasmine Young, for the wealth of information that she continues to share with us and her generosity of inviting you to receive some top-notch legal assistance and advice and consultation for free, y'all, for free.
Make sure you listen to the podcast.
Yes, check it out. Listen to the podcast. Check out our show notes. Pay attention to our website and newsletter with all this information. Take her up on that special offer. And until next time, we hope to see you here on Unlocking the Club for more of this riveting content. Until next time, be well.
Thanks for listening to Unlocking the Club. If this conversation resonated with you, subscribe to our podcast on iTunes or your favorite streaming platform so that you can experience every episode. And follow us on social media, where you'll hear about future guests, access special features, and connect with this amazing community. Head on over there and let us know how you are unlocking the club. Until next time, peace.